Officers Protection Act to a case of termination of employment, holding that any action filed outside the 3 months limitation period is statute barred, except where there is a continuance of injury. He cited INEC versus Ogadibo local government area, Aremu versus Adekanye, and Sylvia versus INEC. Citations were all provided. He submitted that since the Supreme Court in Aroyame applied Public Officer Protection Act to employment termination, the present case commenced outside 3 months from accrual of the cause of action is foreclosed by limitation. Relying on the doctrine of precedent, the Learned Defense Counsel stressed that Supreme Court decisions are binding, and where there is conflict, the latter decision prevails. He cited CBN versus Okoje, Osape versus FCE, Arusi versus Agu. Citations were all provided. This court is therefore bound to apply Aroyame, a 2022 case, and hold the suit statute barred. The defendant submitted that where 2 Supreme Court decisions, I have that already. The defendant relied also on Bakari versus NRC and NBC versus Bankole, where the Supreme Court held that POPA-like provisions, that is the Railway Act and NBC Act, protect public officers when the act complained of was done in performance of a public duty. The only exception is where the dispute is based on a specific contract with distinct terms. Here, the claimant's case concerns the termination of appointment, which was on the 23rd of March 2023, an act done in the course of the defendant's statutory public duties. Since the suit was filed on the 23rd of October 2023, 6 to 8 months later, it is statute barred. Now, I'll go to the decision of the court. I've carefully examined all the processes filed in this suit. The motion on notice, which is the preliminary objection filed by the defendant, exhibit standard and the written submissions of claimant, and it is my humble view that this court is faced with determining whether this case is statute barred, having been cut off by Section 2 sub A of the Public Officers Protection Act. The motion of the defendant as regards this suit by this preliminary objection, counsel argued that the claimant's case is statute barred and that she received the termination letter on the 19th of April 2023. Meanwhile, the suit was filed on the 23rd of October 2023, which is a period of 6 months, clearly outside the 3 months limitation period prescribed by POPA. It is no secret that the issues raised by the defendant in its preliminary objection touches on the adjudicatory powers of this court to entertain this suit and has to be determined first before proceeding to the substantive suit. It is also the defendant's contention that that where a statute prescribes a period within which an action must be commenced, legal proceedings cannot be properly or validly instituted after the expiration of the prescribed period. He noted that the defendant is a public officer within the context of the Public Officers Protection Act, and this is why the defendant raised this defense that the suit is statute barred. Generally, where an action is statute barred, the effect is that the cause of action is or becomes extinct by the operations of law, and it can no longer be maintained in the law court, as the claimant would be left with plain cause of action as his right of action has been put out or extinguished by law. See the cases of Aroyame versus Governor Edo State, citation provided. In the case of Kashe versus Gwagwa, the Supreme Court had also held that to determine if an action is statute barred, it is the originating processes that the court should look at to find out the date that the cause of action accrued. The court would also look at the date of the accrual of cause of action and compare it with the date the action was filed to see if it is indeed caught up by the statute of limitation. So in a nutshell, in order to determine whether an action is statute barred or not, the court examines the originating process, the statement of facts together with the evidence of record, where the action is commenced by originating summons, the affidavit evidence profiled for and against the action, so that the court knows for certain when the wrong complaint occurred, which should be contextualized with the date the originating process was filed. See, as Saburo versus Pan Ocean Oil Corporation Nigeria Limited and Ogundipe versus NDIC citations are all provided. It follows, therefore, that the cause of action accrues on the date on which the incident giving rise to the right of action accrues. See also the case of Kashi and Gwagwa citations earlier provided, and Yahweh versus NSWIC. For emphasis, accrual of course of action is the event whereby a course of action becomes complete so that the aggrieved party can begin and maintain his action. A perusal of the originating process and the evidence before this court, it shows that the claimant's cause of action was against termination of employment done on the 23rd of February 2023 and stoppage of his salaries in March 2020, which she alleges as wrongful, illegal, unlawful, null and void, and to no effect whatsoever. The defendant contended that the claimant's cause of action arose in February 2023 when she was terminated by the defendant. The facts and evidence before this court shows that this case was filed on the 23rd of October 2023, meaning that it took the claimant 8 months for her to institute this action. The question that becomes pertinent here is whether the Public Officers Protection Act, which is a limitation law in the instant case, is applicable to this employment contract between the parties. The law generally is that actions against public officers for any act done in pursuance or execution or intention or intended execution of any act or law or of any public duty or authority or in respect of any alleged neglect or default in the execution of any such act, law, duty, or authority should be commenced within 3 months of the accrual of this course of action. That's section 2 sub A of the Public Officers Protection Act. For a long time, employment contracts were held to fall within the purview of the Public Officers Protection Act, and where actions against public service employers arising from such employment contract were not commenced within the statutory period of 3 months, they risked being dismissed. Therefore, employment contracts for public officers were cut by the limitation period contained in the Public Officers Protection Act. This was the position of the law as espoused in the case of Ibrahim versus Judicial Service Commission, citation provided. This position was, however, changed with the decision of the Apex Court in the case of Revenue Mobilization and Allocation and Fiscal Commission versus Ajibola Johnson. At page 270, paragraph F of the judgment, the Supreme Court held as follows, and I quote, Section 2 sub A of the Public Officers Protection Act does not apply to cases of contract. In this case, the respondent's claim is on a contract of service. Thus, the applicants are not covered by the provisions of the Public Officers Protection Act. End of quotation. The Apex Court's decision changed the law on the questions of limitation of action under POPA and exempted employment contracts from the rule. Hence, by virtue of Ajibola's case, the limitation period prescribed in the Public Officers Protection Act will not apply to employment contracts. The Apex Court, in a wisdom, has gone back to its earlier position in the famous case of Idachaba versus the University of Agriculture, Makurdi. A 2021 case, the citations provided. The court's dicta on pages 23 to 24, paragraph C is instructive. It was an action on termination of employment by a public officer, and the Supreme Court backflipped to the previous position of the law and held that employment contracts it was an action on termination of employment by a public employer, and the Supreme Court backflipped to the previous position of the law and held that employment contracts with statutory bodies are cut by the Public Officers Protection Act. About 2 months after Idashaba's case, the case of Rahamanian United Nigeria Limited versus the Minister of FCT came up and was decided at paragraphs F to D as follows, and I quote, it must, however, be reiterated that the provisions of the Public Officers Protection Act does not provide an impenetrable shield for public officers. The protection is not absolute. Hence, it does not apply to actions for recovery of land, breach of contract, or claims for work and labor done. Again, in Obasanjo versus Wuru Boga, Nigerian Limited, citations provided, the Supreme Court held that contracts are not cut up by the limitation period under the POPA. However, in ABBA, Hello? Hello?
Yes, my lord.
Yes,
With you,
my
my
lord.
lord.
Can you hear me?
Yes, my lord,
Can
we
you
can
try?
hear you.
Okay. So in Obasanjo and another versus Wuro Boga, citations also provided the court held that contracts are not caught up by the limitation period under the POPA. However, in ABBA versus Board of Directors NIPOST, citations all provided, and Rector Kwara Poly versus Adefila, citations all provided. They both decided on 2nd day of December 2022. The Supreme Court railed out judgments on the same subject matter on the same date, by holding different positions. In 2025, in a 2025 decision, that's Chukwuka Okoronkwo versus INEC, the Supreme Court once again held that the Public Officers Protection Act applies in labor and employment claims. Due to the volatile state of the law on these thorny issues, on applicability of Section 2, Sub A of POPA on statutory employment post Third Alteration Act, this court is persuaded but not bound by the recent ruling of the NICN in Antonia Ekwo versus INEC, suit number NICN/EN/04/2024, delivered on Thursday, May 15, 2025, where Honorable Justice Aruro Shegbe raised issues suo motu and drew attention to the fact that most of the cases relied to give strict interpretation to Section 2 of POPA were decided before the emergence of the third alteration of the Constitution of the Federal Republic of Nigeria. The learned jurists noted that the Third Alteration Act did not come into effect until the 4th of April 2011. By settled principle of law, the applicable law to a cause of action is the law in force as at the date the cause accrued. See, Adesanoye versus Adewale, citations are provided. Recently, earlier cases not decided under the auspices of the Third Alteration Act could not have considered the sweeping effect of the new constitutional framework on employment and labor jurisdiction. Secondly, the learned jurists maintain that the Third Alteration Act is by every measure a game changer, as the Court of Appeal recognized in Sahara Energy Resources versus Oyebola, where the court must always inquire where a new legal regime has emerged, which demands a departure from prior principles. The court approvingly cited Bank of England versus Vagliano Brothers, an 1891 case. Citations are provided to the effect that the proper course is to examine the natural meaning of the new statute, uninfluenced by the prior state of the law. He argued that the non-obstinate provisions of Section 254C sub 1, F and H, and sub 2 of the Constitution, as altered, expressly empower the NICN to determine matters relating to unfair labor practice, international best practices, and international labor standards. By their nature, these provisions override all other constitutional and statutory provisions to the contrary. He cited GTB PLC versus Obosi Microfinance Bank. Citations are provided. The implication, according to the learned jurists, is that statutes which encourage or perpetuate unfair labor practices cannot survive scrutiny under the present constitutional regime. Section 2 sub A of POPA, by imposing an unduly restrictive 3 months limitation period, clearly undermines access to justice in employment matters. He held that it is illegitimate, unsuitable, unnecessary, and unfair when tested against international best practices, a test which the NICN is constitutionally bound to apply. He also cited University of Ilorin Teaching Hospital Management Board versus Mariam. Citations are all provided. Arguing further, learned jurists stated that no other established democracy applies a statute like POPA to contracts of employment, statutory or otherwise. The Court of Appeals reasoning in EHA versus UBTHMB is also opposite. A statute cannot be read into a contract of service unless expressly incorporated. Since POPA neither mentions contracts nor contemplates consensual employment relationship, it cannot by implication be imported into a statutory employment contract. See further OPIA versus INEC. Citations are all provided. So in the light of these authorities, he maintained that the proper approach is to construe Section 2 sub A of POPA in the eye of the Third Alteration Act, applying the doctrines of reasonableness and proportionality which are implicit in section 254C, sub 1, sub F to H, and 2. When so tested, section 2, sub A is revealed as incompatible with the constitutional mandate to enthrone fair labor practices and international best standard, and to that extent, it must yield. The learned juries reasoned that to extend POPA to contracts would be unfair, unreasonable, and disproportionate, especially since its unusually short limitation period of 3 months, especially given its unusually short limitation period of 3 months. So in his opinion, laws were intended to guide people, not to trap them unawares, and it would amount to fraud and fraud for government as employers to impose POPA against employees when its wording is silent on contracts and should not be implied into the contract of service, whether statutory or private. At most, a limitation clause could only bind employees if it were expressly incorporated in their conditions of service. The principle of contract requires that all terms must be clear and known from the outset, particularly in employment contracts, which are typically take it or leave it agreements where employees are the weaker party. Accordingly, POPA is illegitimate, unsuitable, and unfair in the realm of contracts of employment and cannot bear the claimant's action. These were the thoughts of the learned jurist. Be that as it may, one interesting thing to note is that despite the oscillation in the judgments of the Apex Court, it appears it is only in the case of Ajibola Johnson Supra that a holistic review of the other cases were done. The decisions in the case of Salecom versus LEDB and Nigerian Post Authority versus CGF citations are provided that acknowledge the contract of service are not caught up by the limitations law were indeed reviewed. I'm indeed afraid that this oscillation of judgments of the Apex Court has left this court, the NICN, with an unsettled state of the law, and for our decisions, and our decision seems to have been bogged down as the appellate decisions continue to oscillate. As lower court judges, and going by the rule that in the event of conflicts, the most recent decision is to be applied, we too have no options than to oscillate in our decisions. See Fabumi versus UI, Edoga versus INEC, and Osunde versus Azodo citations are all provided. Following this rule, therefore, the Court of Appeal in Tetfon and another versus Anas, applying Idachabo and University of Agriculture, Supra, was compelled to hold that the Supreme Court, and I quote, appears to have moved away from the position it took in the Ajibola Johnson's case. And so the position of the law as of today is that the limitation law applies to contract of service. The Supreme Court, in the case of Okoronko versus INEC, National INEC, delivered on February the 7th, Friday, February the 7th, 2025, which was succinctly confirmed and captured it in the following words, and I quote, the appellant knew that his right of action accrued on the 13th day of September 1997, but waited without any justified reason until the 26th day of April 2000 before instituting his action in court. He has himself to blame for his inertia over the alleged breach of his contract of employment by the respondent. The appellant has not also been able to demonstrate that his claims fall within the known exceptions to the application of the Public Officers Protection Act. In the circumstances of this case, the appellant cannot be assisted by the court. The law is that an indolent party cannot be aided by the court. End of quotation. Despite all the opinions expressed, I acknowledge that my duty as a trial judge is to remain bound by the decision of the most superior court in line with its principle of stare decisis. A question of jurisdiction is so fundamental as it touches the root of the action itself, as jurisdiction is a lifeline of an action. And if a court lacks jurisdiction, it automatically lacks the necessary competence to try the case. See Ogbuji versus Amadi, Investor of Ilori versus Adedinro, and Akim versus Ibadan citations all provided. A defect in the competence of an action has a negative impact on the jurisdiction of the court to adjudicate, because jurisdiction is and remains the authority or the power of the court to hear and determine a suit, without which the entire proceedings, trials, findings, orders, and pronouncements are futile and void ab initio, however brilliantly they might have been concluded. I therefore find that the Public Officers Protection Act applies to contracts of employment. Having arrived at this conclusion, I hold that indeed this suit is statute barred, thereby usurping the jurisdiction of the court to entertain this matter. The perennial objection is upheld, and this suit is hereby dismissed accordingly. The relief's canvas cannot stand as there is no foundation on which to base the claims. Judgment is entered accordingly.
As call, please.
This is the judgment of the court.
We're much obliged, my lord.